Joining me now is Lucas Vebber, Deputy Counsel for the Wisconsin Institute of Law and Liberty. Lucas, thank you so much for joining us this morning.
Thank you for having me.
Lucas, I want to first get your reaction to the Dane County judge's ruling on Act 10 earlier this week.
Yeah, I think certainly a shocker and something that's going to have tremendous impacts in our state. But that being said, I think everybody involved in the case has acknowledged that there's still a lot of legal process left here. So I don't think the final chapter has been written yet.
The Dane County judge ruled that Act 10 was a violation of the Wisconsin Constitution's Equal Protection Clause. Can you explain to us the different classifications of employees that were laid out in this particular act?
The first thing that courts will do is they determine what level of what we call scrutiny or what level of judicial review they're going to apply to the claim. Here, we're not dealing with like an immutable characteristic or a suspect class like somebody's race, for example. The classifications that are in play in this case are employment classifications. So the level of scrutiny that the judge is going to apply and did apply here is called rational basis scrutiny. So it's the lowest level of scrutiny that a court will apply to view if a law is constitutional or not. What that means is that the court is effectively looking at whether there was a rational basis for the legislature to make the classifications to treat those groups differently. In this case, the judge determined that there was no rational basis, and so he declared large swaths of Act 10 to be unconstitutional. A very similar claim under the U.S. Constitution was actually brought against Act 10 a little over a decade ago in federal court, and the federal courts came to the opposite conclusion. There, the Seventh Circuit Court of Appeals determined that there was a rational basis for the law. This case being brought under the Wisconsin Constitution is similar claims, but under a different constitutional scheme.
Lucas, Republicans in the state legislature have already moved to appeal this decision. Can you walk us through the process of what happens next?
Yeah, so the appeal has been filed. The next thing that the parties could do is they could ask the judge to stay his opinion, his decision here while that appeal is pending. If the judge doesn't do that, the parties could then ask an appellate court to stay the decision while the litigation is pending. Typically, when you have a case like this that's going to have a significant impact on people in every corner of our state, that's a motion that gets made. Once that's been decided, the next question is, will this case be heard at the Court of Appeals, or will one of the parties move to try and bypass the Court of Appeals to get it all the way up to the Supreme Court quicker? We've seen that in some litigation. So exactly how the appeal itself moves forward is really going to be up to the parties in the case and how they want to handle that.
Can you explain to us what would be the potential impact of this ruling for Wisconsin, whether it's the economy and just workers' rights as well?
Yeah, so from a financial standpoint, we've looked at what would happen if Act 10 were rolled back for both school districts as well as local government employers in the state. For school districts, we found that the financial impact would be about $1.6 billion per year across the state. And then for local employers, it'd be about $480 million across the year. So we're looking at just over $2 billion a year in financial impacts around Wisconsin. And then of course, to deal with those financial impacts, there would be all kinds of practical impacts, both in our schools and in local governments, whether it's reduced personnel or loss of services, increased class sizes. It'll be really a tremendous ripple effect all around Wisconsin if this decision stands.
This case could potentially end up in the Wisconsin Supreme Court, which currently holds a 4-3 liberal majority. Justice Janet Protasiewicz has floated the possibility of recusing herself in this case. Justice Ann Walsh Bradley is not seeking re-election. The next state Supreme Court election is in April. How could these changes potentially impact a ruling in this case?
Yeah, I mean, obviously, a lawsuit like this is probably likely to be for the Wisconsin Supreme Court. What the court will ultimately do with it, certainly nobody can predict. Act 10 has gone up to the Wisconsin Supreme Court before, albeit on a different equal protection challenge, and it was upheld then. As I said, these similar claims were brought in federal court and have been found to, Act 10 was found to be constitutional there. So it's really anyone's guess where this goes, but I think we can certainly expect to see continued litigation, at least in the short term here.
Lucas Vebber, Deputy Counsel for the Wisconsin Institute of Law and Liberty. Lucas, thank you so much again for your time.
Thank you for having me.